Mr. Chair. Bellich.
Thank you, Mr. Chair, and thank the member for his contributions. I just have some responses to that and also some things that were not really part of the title section that he and colleagues mentioned that I thought I could comment on briefly. In terms of the drafting of the Select Committee being deficient, he is a member of that Select Committee. He has the numbers by majority on that Select Committee. So if there's any issue with the drafting, then he is, if not just as responsible as myself, more so. So I would like maybe for him to reflect on his comments in relation to that. Additionally, the Select Committee changes were agreed unanimously with, in fact, his vote. The issue that he reflected on with the mishap in banking is definitely not covered by this Act. This bill. This bill covers intentional theft, not mistakes, not mishaps, not people being forgetful, intentional theft. And that links to his suggestion that the commencement should be delayed. This is not an administrative burden additional to what employers already have to deal with. Employers should currently not be stealing from their employees. They should not be taking money from the people who work for them. This is already an obligation. What we are looking at with this bill is to simply make it an option for police or other prosecution services to, in cases where it meets the prosecution guidelines, take action against what I suspect would be the very worst employers in New Zealand. And also to reflect on some of the comments that this isn't a widespread issue. Unfortunately, in some communities and for some people, this is a widespread issue. For our most vulnerable workers, they often have employers taking from their wages. We heard Ibrahim Omar, the first person who brought this bill to the House in the 53rd Parliament, speak of two examples that he had suffered himself of wage theft. This is an insidious, common problem in New Zealand, and we shouldn't tolerate it. So I reject the suggestion around the change to commencement. Day after royal assent is a standard legislative format, and for this type of bill, which addresses an existing wrong and doesn't require any additional thought by employers who should already not be stealing, I don't consider it's justified. Additionally, I commend the member Vanessa Wienick for her good Google search in relation to the word theft, but it is well understood and defined in the Crimes Act, so I believe it's the appropriate word to use in this instance.
Mr. Chair.
Grant McCallum.
Thank you, Mr. Chair. I'd just like to talk about the commencement date and actually from a rural point of view, because whilst my colleague previously discussed the impact on general business, I wanted to speak about the commencement date from a rural and a farming perspective. And actually there's a number of organisations in the farming sector, and one of these is the dairy sector. So when would be a better commencement that would fit their financial year so that they've got time to understand the changes and to line up with it? And that might be the 1st of June, because the financial year, for the people on the other side who've never run a business and don't understand what the rural sector's like, this is actually quite an important time. Being a farmer at that time is very stressful, so we've got to give ourselves time for the people to understand what the change is, when the change is coming, and the education required. The dairy sector are particularly busy in this period. They need to know for certainty when it will come in and give them time to learn so that we can go out to have personal consultation, give time for that to happen, which is why I would suggest the 1st of June 2026 might suit the dairy sector, because it gives them time to really understand that actually this is a potential criminal act that they could deal with, and that I think that's really important. Right now, the other farming sector, boy, they're getting wound up on the other side. It's obviously concerned about what I'm saying, but clearly clearly, and it's so. What the other area is the sheep and beef farming sector. Their balance date is slightly different. Usually, it's the end of June. So, just maybe we could look at. We have to work out which date suits the farming sector. In fact, we could have 2 commencement dates, one for each sector, possibly. One could be the 1st of July 2026. That may be more appropriate for that sector, because it just takes a while to let people know and understand so they don't get caught out by the word intent. The word intent, because proving that intention is a real thing. And theft, no one wants the criminal be held up for criminal situation. It's just got to be very careful about that, because the stress when you actually have to pay a lot of people, and understanding the stress of making sure you get it right when you could potentially be held up for a criminal act, I think is really, really important. So I would say to the member, I would really appreciate it if you could consider those different types of businesses in the rural sector and when they make. So thank you, Mr. Chair. I appreciate the opportunity.
Question is, that clause 2 stand part. All those in favour say aye. To the contrary, no. The ayes have it. Party vote is called for. Conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa New Zealand.
15 votes in favour.
ACT New Zealand.
11 opposed.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
6 votes in favour.
The ayes are 63, the noes are 60. The question is agreed. Members, we come now to clause 3. This is a debate on the Principal Act. The question is that clause 3 stand part. The question is that clause 3 stand part. All those in favour say aye.
Aye.
To the contrary, no. The ayes have it. Members, we come now to clause 3A, debate on the amendment to section 2. The question is that clause 3A stand part. The question is that clause 3A stand part. All those in favour say aye.
Aye.
To the contrary, no. The ayes have it. Members, we come now to clause 4. This is a debate on new section 2220AA. The question is that clause 4 stand part.
Yeah.
Honourable Casey Costello.
Mr Chair, I would first like to sort of take some time, because it's a little bit odd for me to be speaking and I feel a little bit like I'm out of sorts, but I'd first like to just ask the member around supporting the amendment that New Zealand First has put forward. And I'd like to take a bit of time to kind of explain why New Zealand First's position is where it is on this piece of legislation. Firstly, just if you'd indulge me, Mr Chair, the background on this space is that I have done a lot of work in the labour exploitation area and recognise the vulnerability of these communities, and therefore have had to rely a lot on the immigration legislation that looks at the protections for temporary workers and unlawful workers in this country, and that there is a real disconnect around the balance between those who are vulnerable workers for different reasons, and that they have a position where they are losing wages. At the same time, New Zealand First is a strong advocate for our New Zealand businesses, for our card-working Kiwi battlers, our farmers, our entrepreneurs, our small business owners, that are incredibly diligent employers. They rely on their workforce significantly and treat their workforce incredibly well, because they know the investment that they have made is the backbone of their business. So we are talking about a very small sector. Our concern New Zealand First had in this was that, and it's been touched on in the discussion so far, that we needed to ensure that there was not only intentional actions, not only the mens rea to deprive, but that there was no reasonable excuse. And that will capture, I think, a lot of the concerns that's been raised in the House today, is that if there's a payroll glitch, if there is a delayed timesheet, if there is a dispute over a timesheet, if there is a cash flow issue, all of those factors that would generate a reasonable excuse would ensure that this component of legislation is really focused on those who we are targeting, not the hard-working Kiwi battlers that we know contribute so much to the backbone of our economy, but to those who maliciously and intentionally seek to use their power control of vulnerable workers and not pay them. And I know we've talked a lot in this House, and if you'll indulge me to explain further why this is an issue, we've talked a lot about the personal grievance model and the opportunities. The challenge with the personal grievance model is, yes, we can go through the employment process, but when we're dealing with employers who are intentionally intending to deprive workers, the grievance process is seldom used, and if it is used, there is no recourse or exposure to the employer regarding their reputation. And brand reputation is a significant issue. That when there is a company that is held accountable for something as serious as a crime, then there will be a change in mindset. There won't be an invisibility about this process. So I think it's important to get some context, and the reason New Zealand First is speaking on this legislation is because we recognise that just as we have hard-working Kiwi businesses, we have hard-working employees who, on occasion, can be victimised because of that power imbalance. And I think it's important to recognise that when we talk about without reasonable excuse, when we're talking about this, the protections that we've expressed and concerns in this House about the onerous conditions, there are no onerous conditions. Most of our employers are doing exactly what they do, and there's no additional conditions coming from this legislation. They pay their staff. They make sure their duty of care to their employees is met. But we are talking about the employers who will profit off the backbone of hardworking New Zealanders who are here to make a buck. And I think this is where we want to see the balance. So my question really is asking the member to accept this amendment to recognise that intention and without reasonable excuse provides the balance that we think is important in this piece of legislation. Thank you, Madam Chair.
Mr Chair.
Kamala Billich.
Thank you very much, Mr Chair, and thank you to the member for that very thoughtful contribution to this debate, which I think does really sum up the purpose of this legislation. It's not meant to punish people who have done no wrong. It's not meant to be an extra bureaucratic cost. It is simply punishment for those who intend to commit theft. And so I'm grateful to the member for providing this very good amendment paper to the House, and I do support this amendment paper. I think that it, in both of its major changes, really adds a clarity to the bill and clarifies that it's not a bill that covers mistakes in payroll, it's not a bill that covers errors, it's not when people forget, it's intentionally without reasonable excuse. It really makes that wording stronger, and so I do thank the member for that suggested wording, and I do support this amendment bill. I also support the aspect of the amendment bill that makes this, I think, a better piece of legislation, is making sure that the way that theft is treated in relation to this new small part of the Crimes Act is consistent with the rest of the Crimes Act as well. So I think it's a beneficial amendment, and I think that I encourage all members across the House, even if you're not voting for the substantive bill, I do would like to request that you consider this amendment paper, because I do think it is beneficial and makes the bill a better piece of, hopefully, legislation. In relation to the members' other comments, I agree with that. This is about balance. It is about making sure that there are serious consequences for serious wrongdoing. And I know that I speak for the whole House, where we do, of course, support the work that employers do. We know it's not always straightforward to be an employer, but there has to be a line. And the line in this case is when you intentionally, without reasonable excuse, take money from your employee. There must be consequences for that. It helps good employers, it helps employees, It makes people answerable for what is a crime and creates balance within the Crimes Act to make sure that crimes that employees commit and crimes that employers commit are treated the same under the law. So I thank the member for that contribution and encourage the House to support the amendments that she's proposed.
Carl Bates.
Thanks, Mr. Chair, for allowing me to take an additional call on this, and to start off by speaking about the amendment paper. The member raised earlier the opportunities we had to improve the bill, and we and the National Party want to just thank New Zealand First for bringing this amendment paper to the table and indicate that we'll be supporting the amendment. Do have some concern about the wording without reasonable excuse, and I expect that there'll be some litigation through the courts over time to determine exactly what without reasonable excuse would mean. That could be somewhat expensive, could have some impact on employers who have genuinely, for a particular reason, a set of circumstances, ended up with a delay in payment of their employees or withheld the payment for a reason they have felt is entirely reasonable, but becomes, in the view of the courts, not a reasonable excuse. And I suppose that speaks to a broader concern that we still have about the substantive clauses of this piece of legislation. One of which being that it does, despite the assurances that this isn't a high burden for business, that it isn't something that businesses who are doing the right thing are going to have to worry about, it will add to the challenge that good employers have who are trying to do the right thing all of the time, and can create, or has the potential to create, whether they be farmers, as my colleague Grant McCullum spoke about before, or other businesses, and that could create additional mental health challenges for employers, particularly small and medium businesses that this country is built on. And so I'd like the member to speak to us and share with us her view, Mr. Chair, on the potential impacts of this legislation on the mental health of small and medium employers across New Zealand. I'd also like, Mr. Chair, her to speak about, in terms of the substantive intent, and I hear this intent particularly focused on employers who employ migrant workers. This has come up a number of times today, Mr. Chair, about the role of employers who have taken advantage of migrant workers. And it makes me wonder if the member would consider more targeted legislation or regulation even that focuses on that particular problem. This potentially is a very broad brush approach that captures all employers, even those, as has been said, that are doing the right thing, that are trying to go about running their businesses effectively and efficiently to grow the productivity of this country, to grow the wages and salaries of employees through doing that. And so an example of what I'm saying would be the removal, for example, of accredited employer status for employers who are caught doing wrong in terms of this type of intent. So if that is the true policy intent behind this piece of legislation, rather this bill, then I wonder if the member would be open to either a bill that is much more targeted in its policy intent, or engaging the minister on regulation, for example, that did something, for example, like the removal of the accredited employer status in those immigration cases. The last thing I'd like to raise at this point, Mr. Chair, is regarding the data on the size of the problem. We've heard the anecdotal scenarios that the member has shared. We heard several anecdotal examples in the Select Committee, but I still am yet to hear data. In 2024, X number of these cases were identified. In 2023, Y number of these cases were identified. In 2022, C number of these cases were identified. And Mr Chair, I really struggle with adding a piece of a bill, potentially a piece of legislation to the statute books here in New Zealand to add another layer of administrative burden, something else that HR practitioners have to get their head around without that data. Mr Chair, I'm keen to hear the member's response to that, those questions.
Mr Chair.
Cameron Bellich.
Thank you, Mr Chair. I'm happy to respond. I want to point the member to the existing offences under the Immigration Act. In 2009, there are special penalties already for the exploitation of employees and temporary workers that are made under the employment legislation, and that comes with a penalty of up to 7 years imprisonment and a fine of up to $100,000. So my response to the member is the idea about targeted legislation obviously has merit. It's already in place in our statute books, and what this bill intends to do is in fact provide the protections that migrant and temporary workers currently have to the rest of New Zealand in respect to wage theft. In respect of his question in relation to data, the document I pointed out to him earlier that was provided by the Ministry of Justice to the Select Committee states that in 2020 there were 77 cases of wage arrears in the Employment Relations Authority, 2021 61 cases, 2022 107 cases, 2023 130 cases, and 2024 30 cases. Now, not all of these cases will necessarily reach the burden, the higher threshold of theft, but some of them may. And it does show that there is a significant issue of wage arrears currently in New Zealand that is being dealt with in the Employment Relations Authority. I can assure the member that the cases that get to the authority will be a very, very small percentage of a much larger issue. And like the member, we heard very, very compelling stories of exploitation through the Select Committee process, and I want to acknowledge the people that were brave enough to share those stories with us. This is a big problem. We do need to look at this data, and I would encourage, if this bill was to be passed, the collection of data to make sure that in the future we are able to have this offence put in place and also look at the instances of when this has occurred. The last thing I want to just remind the member is that this is a prosecution provision in the Crimes Act. This means that it has to reach a very high threshold under the prosecution guidelines. And so I appreciate that, of course, with all changes to statutes, there's an opportunity for arguments and case law, and that's the foundation of our justice system. But to prosecute someone for the crime of wage theft, I have confidence in our prosecutors and our police that they will only take cases that are likely to succeed. In fact, that is the wording in the prosecution guidelines, that must be a criteria that's met. And so I understand the members' concerns, but I think that the way that we have prosecution set up, the good people that we have working in the police will make sure that that is taken into account at the time that they decide to prosecute that offence.
Grant McCallum.
Thank you, Mr Chair. I appreciate the opportunity to speak to this next part of the bill. Firstly, on the amendment paper that our colleagues in New Zealand First have put up, I'd like to thank them for doing that. It's certainly for a piece of a bill that is, I think, of questionable use, at least adds a little bit more certainty for small business owners in New Zealand, in particular the small business owners, because of the extra stress that it could well put on them from having to deal with the burden of potentially being accused of a crime over getting payment wrong. So I'll just actually pick up on what the member said towards the end there about the data. I think it would be really helpful around the data if we get a breakdown of the data of where, if it does exist, of where small business versus large business, just to see where the burden sits in this space. Because with small business owners, being one myself, where usually it is up to the small business, the owner, the worker, the person who does all the work in the business, to actually have to do the bookwork and all that themselves as well, whereas the larger businesses have specialist skills and people employed in the space. So it would be really, really helpful if we could actually have data that separates those out into small and larger companies with more professional people available. And I just, one of the other things that does worry me about the bill is when you look at the, when you put down here the list of the punishments that you've got here, and in terms of the actual, whether it could be imprisonment of not exceeding a year, is that really appropriate in this situation? I mean, that seems to me to be very heavy-handed, and along with a fine of up to $5,000. That is really. But this. So but this is the thing. You're talking about small business people who are the heart and soul of this country, who actually you're putting extra burden and pressure on of potentially going to prison. That is a heck of a burden to put on somebody, in a small business where you've got the day-to-day worries of running a business on a regular basis, and content and a $5,000 fine. It's a lot of small businesses, particularly in the very, very tough economic situation, we find ourselves in now. Another $5,000 fine is a substantial amount of money for a small business to find. So I really would like to think we could maybe have a look at that. And then there's the larger fine of $30,000. That is a significant amount of money. So look, anyway, I thank you, Mr. Chair, for the opportunity to make my contribution on this, and I look forward to the response. Thank you very much, Mr. Chair.
Mr. Chair.
Kamala Bellich.
Just a clarification point, really. The amendment paper put forward by the Honourable Casey Costello would replace the section 220AA2, which outlines what will be liable for, and actually just makes it consistent with theft as currently in the Crimes Act, which I think, again, the member for that, I think that strengthens the bill to have consistency as in what's already a punishment in the Crimes Act.
The question is that Honourable Casey Costello's amendment to Clause 4 set out on AP number 243 be agreed to. All those in favour say aye. Aye. To the contrary, no. The ayes have it. The question is that Clause 4 as amended stand part. All those in favour say aye. Aye. To the contrary, no. The ayes have it. A party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa New Zealand.
15 votes in favour.
ACT New Zealand.
11 opposed.
New Zealand First.
Votes in favour.
Te Pāti Māori.
6 votes in favour.
The ayes are 63, the noes are 60. The question is agreed. Members, we come now to our final debate. This is a debate on amendment to section 223. The question is that clause 5 stand part. The question is that Honourable Casey Costello's amendment to delete clause 5 set out on AP number 243 be agreed to. All those in favour say aye. Aye. To the contrary, no. The ayes have it. I'll report this bill with amendment. Such a conscience.
Members, the House is resumed.
Madam Speaker, the committee has considered the Crimes Theft by Employer Amendment Bill and reports it with amendment. Madam Speaker, I move the report be adopted.
The question is that the report be adopted. Those of that opinion will say aye. To the contrary, no. The ayes have it. Members, this debate is now, sorry. Oh, it is too. Thank you. This bill is set down for third reading next sitting day.